Hello, good morning. Is it the 6th semester indirect access class? So let us start today relating to appeals. I think so. Yesterday we were supposed to start with appeals. Yesterday I gave you a brief introduction relating to the appeal, right? Now, whether it is an appeal or a revision, what do you mean by a revision? Revision here is whatever may be the order which is issued by the authorities, and we are not satisfied with that order and we want some change to be made. So that means our order should be revised. In such cases, we have to see to it that we will apply for revising the order. So that's the reason why we need to take into the account the order, because when we want some change supposed to be made in the order, then automatically relating to that, we have to give the information to them. The information, when the people, when they have given an order and when they want to change that order, unless until the authority who has issued is not satisfied with the documents stating that what he has given is right or wrong. Based on that, only people can able to give you this revision. That's the reason why, first of all, you have to prove yourself that whatever the order issued by the authority is not applicable to you on so-and-so grounds, and you are eligible to get the order supposed to be a revised one. That is what you have to communicate. You have to prove yourself. Then only the orders, if the authorities are satisfied and they agree with your whatever you say, then only whatever the order earlier issued can be revised. If not, that revision cannot be taken into the account. So that's the reason why, whether it is for an appeal or for a revision, whatever may be the consequences, first what you have to do is, first we have to make an application. We have to file an application, and when we want to file an application, it has to be according to the rules, which is being specified under GST appeal rules. So the general rules for filing a GST appeal, that is what we have to take into the account. So now first, here the person who wants some justification or some revision or some judgment, so definitely has to make an appeal. So the order which is issued by the authorities was not satisfied by the person who has received, then he can go and he can make an appeal. So for that, he has to make an application. See, without making an application, he cannot put forth his argument. So it's a reason why, first of all, he has to make an application. So appeal should be filed in an approved format along with the requisite fee. See, for your examination, also you are putting up an application and you are paying the fee. We are calling that as examination fee, and examination application need to be submitted. For admission, you have to pay the admission fee. You have to put up an application for admission. And after putting up the admission application also, when you are joining into an organization, that is a college, there one more application, that is they'll give you an admission application only, they say. So first is for the entrance purpose, you are writing an application. The second one is for the admission, you are writing an application, and then payment will be made. First also you will make a payment for the application for the registration purposes. That is the amount which you are supposed to pay. So everywhere you take into the account, why I'm giving you these examples is, when you want to put up an application along with the requisite fee, it is acceptable. Then only your case will be studied. If not, the case will not be taken up. So that's the reason why, first of all, when you are making an appeal, see to it that appeal should be filed with the approved format. Approved format means we'll write it in a white paper and we'll submit and we say this is an application. This will not be acceptable. See, if you go to our examination branch will give you an application. Whatever you say, they will not accept. So like that, even the authorities under the GST Act, they also prescribed one format for an appeal. That format only we have to take into the account. And the amount is to be payable, then only your case will be considered for the consideration. The second is, either an officer or a commissioner of GST is appealing, then fees will not be applicable. Now, if the consumer or the customer or a dealer or a supplier, if he wants to apply, then he has to pay a requisite fee. But if it is the authority who is doing so, then for them, there is no need for them to pay the fee, because they themselves only making an application for an appeal. So in such cases, for them, they are exempted from the payment of the fees, whereas supplier or a distributor or a service provider or a dealer or a trader or a customer or a consumer, if he wants to file an appeal, then automatically he has to pay the fee. The next, they say that the appellant or the authorized representative can appear before the GST officer. Now, appellant means the person who has made an appeal. He can be called as an appellant, or an authorized representative. That means an officer on behalf of the government. They can appear before the GST officer, because now we have made an appeal for which we have to prove it. So automatically there is a need that we have to go and approach them, and we should be in present in the before them, so that we can discuss or argue relating to the issue which we thought of it. Now, an authorized representative, like let us say I'm a applicant. That means I have appeared for an issue. That means I have to go to the officer and I have to put forth my argument. Or if I am unable to go, then on my behalf, I can send either my relative or an employee, my employee. So because mine is an organization, in such cases, I can authorize one person as an agent. He can be an agent, he can be an employee, he can be my relative, he can be my practicing lawyer. So he can be a lawyer, he can be a qualified practicing chartered accountant, or a retired officer of the tax department, or a tax return preparer. So because all these people are doing on my behalf, they are working on my behalf. If I'm unable to go and present my issue, automatically I can send any one of them like this to the authorities, so that the authorities can make an application. Right? This is one way of doing the things. The next, what we will do, we will take up into the account is the next, the board. The board or the state government, on the recommendation of the council, fix monetary limits for appeal by the GST officer to regulate the filing of appeal and avoid unnecessary litigation expenses. Now, either a board or a state government, on the recommendation of the council, they'll fix certain monetary limits and see to it that the monetary limits here is like, let us say 20 lakhs, your turnover is over and about 20 lakhs, then you are, and whatever may be the argument, like let us say the dispute arises between the authorities and the concerned party, if they think that it is advisable to go for make an appeal, then only they will see to it that it can be accepted. That means the monetary limits for appeal, like for 20 rupees, 10 rupees, for 100 rupees, if there is a discrepancy relating to something, relating to this areas, probably for each and everything, minor things, we cannot make an appeal. Here, to make an appeal, automatically see to it that it should be an issue. An issue need to be acceptable by both the parties, need to make an appeal. That's the reason why what actually the fee is also supposed to be collected, and there is a discrepancy relating to the payment of tax. So that tax also they have to see to it that is it a quite amount for which if this argument or this agreement is not taken care, but because of that both the parties may be affected because of that payment, or it is an important issue which earlier was not discussed, probably now it is required, so they need to discuss about this. So probably all this will be taken into the account. That is the reason why it is the board or the state government will decide, and they'll give a recommendation to the council that fix up a monetary limit for the appeal, and the officer should be regulated for filing of an appeal. And because all these are being doing, why? Because it is to avoid unnecessary litigation expenses. So every case they will take into the account to decide whether to admit or not to admit. Also, they will decide. So it is unnecessarily, they will never waste their time. So here, whether it is from the side of the customer or the consumer or a supplier or a distributor, or from the authority side also, they'll see whether this issue can be proceed for an appeal or not. They will decide like that, and accordingly, they will take into the account. So that is one point. The second, they say that whatever may be the decisions which are taken, especially they want to decide by the GST officer. Usually, whoever may be the concerned party, he has to see to it that whether it is to be decided by him or not. In any case, we have a problem with that person only, then automatically the person will decide that, like, let us say you have, if you have a problem with that person, so we don't want to meet that person, we would like to go to some other person. In such cases, what happens, they will make an order and say the order will be transferring the proceedings from one officer to another officer. See, you are approaching me, you have a problem with me, you don't want to approach to me. Then in such cases, what you're doing, that you want the case supposed to be shifted from me to some other. So you will put forth a request stating that we don't want to meet because the problem is with them only. So we want to transfer our case proceedings from this person to some other person. So that can be taken place provided the GST officer could able to understand the issue. The second thing what they say is like can confiscate or retain books of accounts or documents. So like let us say you may be transferring the case from me, but books of accounts etc. either you can retain with me, or these books and accounts which you are think that need to be permitted to some other officer. See, when I'm not looking at the case, then automatically what I have to do, I have to change all those things which I have need to be transferred to the party who is looking into the matter. So, or I can make myself available, see to it that I'm not involved, but all documents are with me so that I can prove it, stating that this is the problem. So there are the two things. One is transferring the proceedings from one officer to another as one, and an order to confiscate. That means I may be there, I will give all the information. Probably the other party will take the decision, or I may retain the books of accounts with me, or I can shift this books of accounts to some other. Like that, even the documents, books of accounts, or documents, evidences, everything, if you take into the account, that also can be taken into the account. The next, order permitting prosecution under the Act. See, it all depends upon the case. If the case is so seriously, then automatically see to it that whether it has to take a prosecution or not. They will consider the prosecution provided the case is definitely important. Or any order permitting payment of tax. It is only related for the payment of tax, then they will take that into the account. Or any other sum in installments. If you are not able to pay the amount, then they'll see to it that the other sums will be taken. Like if you're unable to pay at a time, it may be allowed to pay in installments. So these are the things which we have to be considered taking into the account under the appeal. Now, after this, we have to see to it that what stages of appeals will be taken or considered under the GST Act. Now, here usually they'll take into the consideration the first stage, the second stage, the third stage, like that. Here usually what they'll do is they'll see to it that whether the first situation, how it has to be reacted, the second situation, how it has to be reacted, all that they have to take into the account. Now, taking that as a basis, they say the first appellate authority or the appellate tribunal, High Court, Supreme Court. This is the procedure which we are supposed to follow. So whoever may be the party, when they want to approach, first they have to approach the appellate authority. The second, they are supposed to approach, like appellate authority decision was not satisfactory, we are not satisfied, then we can go to the tribunal. We can approach the tribunal and we would like to know what decision has been given by the tribunal is acceptable or not. Then if whatever the tribunal says, we are not satisfied with that, then we will go to the High Court. So the next stage will be the High Court. So our decisions will be, see to it, can be decide in the High Court. Then whatever the decision was given by High Court, even probably that is not acceptable, then we will go to the Supreme Court. So these are the stages of appeals. So whatever the decisions which are being given, which are being understood, based on that, automatically we will consider into the account that whether those decisions are acceptable or not. If those decisions are acceptable, probably your problem is solved. If those decisions were not acceptable, then what we will do, we will approach the next authority, the next authority, and the next authority. But Supreme Court is the final. Whatever the Supreme Court says, we cannot go beyond that. We are supposed to see to it that we have to follow that. So Supreme Court is the final decision. So over and above Supreme Court, we cannot move. These are the stages of appeals under GST. The next is application to the appellate authority. So when we want to make an appeal to the appellate authority, then what we have to do, first we have to file an appeal to an appellate authority. and they give a span of 3 months from the date of order issued. From the date of order issued, they'll give a span of 3 months. So within this 3 months only, you have a right to make an appeal to them. If it is over and above 3 months, then automatically we will not have a right to file it at the same time. If, for example, like I'm not available on time, probably I may not be available in the station. I may have gone somewhere. Probably after coming back, I come to know this information. Then I can put forth this to the authorities, stating that in case if there is a time and the time could not be made use for the sake of putting up an application, then what they will do is they will consider if the case is appropriate and required and the genuine reason has been stated, then it can be taken into the account. If not, they may not acceptable because he hasn't come within the time period. So it's a reason why usually to make an appeal to an appellate authority, they gave you a 3 months time from the date on which the decision or order has been passed as per section 107 subsection 1. It is only a prerogative and for an aggrieved person. Aggrieved person means the person who is affected with this order. Okay. And like let us say the right against the decision or an order passed is lying with the authority only. It is not the aggrieved person has any right, but it is for the appellate authority only will have. Now for this, there is a need that the commissioner has to verify the records. So the commissioner need to examine on his own or the request of the commissioner or the state authority or the state tax or a union territory tax, whoever may be called for the scrutinizing the records or the proceedings which are being passed by the adjudicating officer. So when he is scrutinizing the documents or the records, what he has to take into the account first, whether he has empowered with the direct transfer of proceedings from one officer or not. He also has to see to it that retention of books of accounts, registers, and other documents. He also see that an order approving the prosecution under the Act and order concealed under Section 80 for the payment of installments, etc. This also need to be filed against the order. Now, coming to the format of an appeal, they say that the section 107 subsection 5 provides that every appeal shall be in a prescribed format of the appeal, right? And it is to be submitted in the form GST application 01. GST, form GST APL. APL stands for application GST 01. Together with the prescribed documents electronically or notified by the commissioner, all this are supposed to be stated and send it to the person, right? The next, according to the rule 108 and 109 of CGST rules 2017 provides that a certified copy of the order or a decision appeal made against the adjudicating officer may be submitted within 7 days. So once you made an appeal within 7 days, they also see to it a certified copy or an order supposed to be submitted along with the application which is being submitted under section 107 subsection 1. Now, whenever you are submitting an application in the examination branch, they'll give you any acknowledgement. Usually in universities on any other proceedings, like let us say if you have submitted something, they are supposed to give you a acknowledgement. Acknowledgement is that is proving that you have submitted in time. and further anything happens, you can show this acknowledgement saying that, yes, I have formalities are being fulfilled within the stipulated time. That is acknowledgement should be given. Now, whether it is being given in all other cases or not, but in case of an appeal, automatically they'll give you an acknowledgement. That acknowledgement will be issued as specified in Rule 26 in the form of GST application 02 by appellate authority. By appellate authority, you will issue GST application 02. That is an acknowledgement which is being issued. Okay. The next, extension of time by an appellate authority. If the time is not sufficient, then if they think that it is necessary to extend, then the time can be extended, and the time will be extended for a period of 1 month. Extension time can be given, or more than 1 month. It may even prescribed to be given a period of 3 to 6 months also. It all depends upon the person who is dealing with that case and think that the case supposed to be given a time for more than 6 months, more than 3 months, or more than 1 month. So it all depends upon the case. It all depends upon the authority who is dealing with. If they deem fit that the case can be given an extension time, then automatically the extension time will be given. Now, coming to the next is appointment of an appellate authority. Who can appoint as an appellate authority? Now, in the hierarchy of authorities, if you take into the account the powers, the rights, the duties of appellate authority is over and above the commissioner. If they are of same rank, if you take into the account, appellate authority has more power. Appellate authority is related to these matters. So automatically, here any officer can be appointed under the GST Act as an appellate authority. So here the government or the GST Council will think that who can be applied or appointed as an appellate authority, that they will decide and they will appoint. Now, what are the powers of an appellate authority has? The appellate authority can exercise its powers regarding to the discovery and inspection of the matters. He also exercises the authority to attend and examine him on the oath. Oath can be given for them. Like for that matter, for certain, like a medical officer, he has to give an oath. For a lawyer in the court, they are supposed to give an oath. So like that, a few people, when they are entering into that particular positions, they are supposed to give an oath. So that is also, they have to examine, they have to attend him on oath. That is also need to be taken, considered. The next power he has is, he can compel the customer or the supplier or a distributor to produce the books of accounts, other records required him to carry out this particular duties. So that's the reason why he can insist the people to produce. And he also has a power of civil court, which is made under the Code of Civil Procedure. So when he has to take any action, he will taking the civil court as a base. So he has that much power. He also has deemed to be a civil court for the purpose of Section 195. So here they say that the Code of Criminal Procedures, which is supposed to be followed according to Section 195, that will be followed by an appellate authority. Now, in case of proceedings like before appellate authority, a judicial proceedings within the meaning of Section 193 and 228. Now, what I mean to say here is the appellate authority is like our court. So the powers, whatever may be the way they are dealing, all that they'll deal, probably they may be called as appellate authority, but they are dealing like a judge. So the judge, whatever may be the powers they have, whatever may be the case, the sections which they are supposed to follow, supposed to take the decisions, all those legal judicial powers they'll have. So that is the reason why they'll be being called as an appellate authority. See, any person, once they have appointed as an appellate authority, that means that position has certain power. That power is supposed to be exercised by that person once he has been appointed as an appellate authority. And the way the court proceedings are being taken place, the sections which are being followed, the same thing is also applicable in this case also. That's the reason why they will be called as an appellate authority. The next is appeals to the appellate tribunal. Now, appellate authority, we have appeared and we don't know whatever the decision was given, we are not satisfied. We think that they have not done the justice. Then we will automatically make an appeal to a tribunal. This is the next stage which we can approach. So when we are approaching to the tribunal is like a court. It is the next level to make an appeal after the appellate authority. So they have to, the appeal can be filed against the order in appeals passed by appellate authority, or a revision which can be taken up by a revisional authority. So here we are approaching the tribunal. The tribunal is comprised of two-tier tribunal. Now in the courts, we have a bench. Bench is not the bench which we have it in the classrooms. Bench here means like they will say that it is a category. They'll say that it is a bench maybe consisting of one judge or a two judge or a three judge. It all depends upon the case which need to be argued based on the case. If the case is so simple, probably they may prefer for a single bench. Single bench means only a single judge will be there. If they want, this case cannot be whatever the single bench court or the judge which is given decision is not appropriate, then they can authorize to send it to the another bench where there can be more than a judge can be there. So like that, even in the tribunal also, we'll have a national bench and a regional bench. It can be called as a state bench or an area bench also. So the jurisdiction under the two constituents. So they'll take the GST tribunals which has been well defined. That means their hierarchy is been well defined, and it is been, the benches is also been defined. And here the authority need to hear about the appeal. That's the reason why whether it has to go for a national bench or a regional bench. So they'll see to it that to whom it is to be directed and who has to give a decision. So appeal from the decision of a national bench will be related directly to the Supreme Court. So it is directly goes to the Supreme Court. Whatever the state bench as the decision which is given by a state bench will lie with the jurisdiction of High Court. So the decisions which are given based on these benches, they will relate it to so-and-so area. So that area will be stated here. So when High Court decision, the state bench is giving you a decision which is under the jurisdiction of High Court. That means High Court has given the information, and that decision, if you are not satisfied, then you have to go to the Supreme Court. So automatically you will reach to the national bench. So like that, for every bench has a power and a jurisdiction also that is being confined, and taking that as a basis, you have to take the decisions. Then appellate, whatever the appeal which is made for an appellate tribunal constitutes two-step process. You have a two process or the procedures to be followed. The first procedure, what they say is, while disposing of any proceedings or an appeal, appellate tribunal will be bound by the rules. Now, they will not go beyond the rules. They will see to it that they will discharge their duties which are within the principles and the rules. Now, before taking a decision, they'll follow a principle called a principle of natural justice. Principle of natural justice means whoever may be approached, they will give you the same decision. The decision will not change because the political party appears or an influential party appears. That is the reason why if there is a change in the justice, then it cannot be called as a principle of natural justice. It is whoever may be, whether influential or non-influential person approaches, they will see to it that they will give you a same justice. That's the reason why it is called as a principles of natural justice. Now, they will take into the consideration all provisions, all rules of GST Act. At the same time, the authority who is regulating its own procedures also will be considered for giving a decision. The next, they'll take into the account in the discharging of the functions, the appellate tribunal shall execute the same powers as vested in civil court. So I told you already, the civil court, what all the powers are there, the same powers will be exercised even by the appellate tribunal. So tribunal is only a name which is different, but it is also called as a court. So it is being taken into the account, and they'll see to it, they'll examine the person under oath, they'll ordering the guilty party to produce the necessary documents or evidences or affidavits, or examine the witnesses or any other matter, all they'll consider into the account, then only they'll give a decision. So all these procedures will be followed. Now we have to make a procedure for making an appeal. So when an appeal is to make for a tribunal, an aggrieved person, that means the person who has not agreed with that order, so he will make an appeal. He can file it within 3 months from the communication of the order under appeal was received. So he has to make a file within 3 months. Okay. The tribunal has a power to overlook delay up to 3 months in case of appeal, or a 45 days in case of a cross objections. So they are giving you a time limit up to which limit they can take care of this particular case. That is was being stated. Either for a cross objections, it is for 45 days, or for an appeal, it is for 3 months. Beyond the mandatory, being satisfied with the inform of the enough cause for the delay. So they have to inform why there is a delay in making an appeal, or taking that appeal as for the considerations. Then the tribunal, as per the discretion, can admit any appeal involving an amount of 50,000 or less. So if the case issue related, if it is 50,000 or less, it is under the discretion of the tribunal whether to admit or not. That they'll take into the account. And the cross objections by the respondent against such party, order against which the appeal has been filed. So here they'll see to it that who has filed and what against they have filed and what kind of a cross objections they are stating. All that supposed to be stated, and they look into that. That is being taken into the account. Within 45 days, a memorandum of cross objections against any part of the order appealed against, or such memorandum shall be disposed under the appellate tribunal. All that need to be taken care, and in case if within the specified time, if it is not done, for initially any lapses are there, that they'll consider and they'll give a communication for that. Now coming to the rule 110 of CGST rules provided that they say that a necessary documents either electronically or manually supposed to be required by the registrar, supposed to be sent along with the form GST application 05, which is duly acknowledged provisionally under section 122 subsection 5, which is consists of a memorandum of cross objection. In case of cross objection, they have given this. So you have to make an application in the form 5, and they will give a memorandum and also the acknowledgement. A certified copy of the order supposed to be a requisite supposed to be given, submitted to the registrar within 7 days of filing of an appeal. The next, they see to it that the appeal resortation, the requisite fee or resortation of appeal is 1,000 rupees for every 1 lakh of rupees or an input tax credit. So they'll take the amount of tax which is supposed to be payable based on that, either 1,000 or 1 lakh, 1,000 for 1 lakh, that they'll consider, and based on that a penalty or a fine or a 25,000 rupees may be charged as an interest for whatever the case which made an appeal. Now rectification of errors or also will be reference on section 122 subsection 10, may be made before the appellate tribunal, and no fee for application shall be charged for that. So this is what has been considered. The next relating to the application to the appellate tribunal. So when we want to make an application to an appellate tribunal, here under rule 111 of CGST rules 2017, the method of making an application, so they gave a certain procedures to be followed. One thing they say, as per section 112 subsection 3, inform GST application 07 supposed to be filed by an appellant, which shall be filed electronically. It has not manually been filed. It is electronically been filed, and a specified authority along with the documents listed in the portal need to be submitted. And a certified copy of decision or an order of an appeal against whatever has been submitted need within 7 days of filing of an application. They are supposed to give a number. That number we will call it as an appeal number, which is given by a registrar. Now, what actually the pay that is a required pay is to be taken. The appellant is required to pay sum equal to 20% of tax due. So whatever the dispute of tax is taken up, out of that 20% he has to pay as an amount which need to be deposited along with this appeal. Now, and like let us say, in this section, it has been amended to provide a ceiling of 50 crores rupees for filing an appeal before the appellate tribunal. So they have also given a ceiling. That means a rule, a limit, stating that it should not be more than 50 crores. These are the procedures supposed to be followed for making an application for an appellate tribunal. The next, they say the order or an appellate authority or an appellate tribunal, if you take into the account an order relating to this, they say the appellate tribunal grants the party to appeal an opportunity to be heard. Now, this is one more principle supposed to be followed under the justice. First is principle of natural justice. The second one is opportunity of being heard. That means they'll give you a chance for put forth your reason why a mistake has been taken place, or why whatever the order is issued was not satisfactory. What actually you mean to say, you want to prove yourself. So that is the usually for that matter, any decision for that matter, they'll take into the account the concerned party or who are aggrieved party. That means affected party. Put forth, they'll give you a chance to put forth from his side or her side about the data, why he has done like this. So they'll give a chance to state the reason. So once whatever the decision which need to be passed, which they think fit, they will confirm, they'll modify, they will change the decision or an order appealed against, or may refer the case back to the appellate authority. So they have every chance, either revisionary authority or appellate authority, whatever the order was given, that they can give them a chance to revise it, because what they think or what the aggrieved party says, if they think it is right, it deems to be fit, then in such cases, they call back the appellate authority to change. And here one more thing, such directions as the case may be for a fresh adjudication or a decision after taking the additional evidences. They will take the evidences into the account and accordingly they'll do. Wherever, whenever, whatever may be required, those details they'll inquire and accordingly they will proceed. So this is to be taken into the account. So enough cause need to be shown. So always remember, when a mistake has been taken place, that mistake if we accept, and for that we will supposed to give this mistake is happened because of so and so reason, and this reason is not because of us, it is so happened like that. Then if authorities are also satisfied, then automatically your appeal can be acceptable and see to it they can pass a revision order. So that can be done. This is regarding to the order of an appellate authority or appellate tribunal. Now, if that is also not satisfied, then you can go back to the appeal for the High Court. You can go to the High Court, you can go to the Supreme Court, you can see to it that what judgment which is given by the previous tribunal or appellate authority happens to be a wrong decision. Then you can go to any extent and you can see to it that you can file an appeal to the High Court and you admit all such appeal as it is been deemed fit and involves a substantial question of law. All that you can do, and all this can be filed within 180 days, because every appeal, for every application, there is a time limit. The time, within the time only you can make an appeal. Over and above the time, we doesn't have a right to make an appeal. So usually they'll give you a time bound. The time bound need to be taken, and High Court has a power to excuse a delay on being satisfied for enough cause for the same. See, here also, beyond the time also, if you want to make an appeal, you have to give a reasonable cause. If they think it is the delay can be excused, then High Court also will extend the time. It can be admit the appeal. So wherever you go, that will be done, and that is what is to be taken into the account. Then demand confirmed by the court. So whatever may be made an appeal, so they'll see to it that according to the rule 115 under the CGST rules 2017, the jurisdictional officer will issue a statement in form GST application 04, which is visibly stating the final amount of demand confirmed by the High Court. That means because the payment of tax only if you take into the account, and if appellate authority or tribunal could not able to, whatever they have given you are not satisfied, you will go to the High Court and High Court decides. And High Court says that this is the amount which you are supposed to payable. Then you have to pay that amount. That is to be a demand need to be confirmed. You have to confirm that. Now coming to the disqualification for misconduct of an authorized representative. Now here authorized representative, we already discussed who can be an authorized representative. Authorized representative can be a relative, he can be a practicing chartered accountant, he may be a practicing lawyer or anyone. So in such cases, disqualification for misconduct, he says. So that means he found guilty of deviant behavior or a misconduct with reference to any proceedings under the Act. In such circumstances, Commissioner, after providing him with an opportunity of being heard, will disqualify him from being an authorized representative. So that means here he'll see to it whether he is qualified or not. If he is guilty relating to that, then he may be considered that this case should be disqualified. Now, coming to the next chapter is about the miscellaneous provisions under Unit 9. Here, they gave you, the first one is anti-profiteering. So here, what actually exceptional provisions which the GST law has given into the account. This is like a controlling measure against a trade and an industry. So here, whoever maybe has registered under the Goods and Service Tax Act, they say that a couple of reasons also supposed to be stated under this clause, anti-profiteering. These are the different types of credit restrictions which are being given. What I understand here is, like, let us say, see, you are manufacturing a product. See, as I told you earlier, we used to have, once the product is manufactured, it has to levy the excise duty. So once the raw material, like I'll give you an example as a coconut. Coconut is a raw material converted into oil. That means a manufacture has taken place. Once the form has changed, so it has to attract excise duty. So we have to levy the excise duty, the cost of manufacturing expenses, cost of raw materials. Raw materials, if you purchase from outside, automatically sales tax is involved. Now, coconut, if you are purchasing from outside, getting into the factory, then automatically when the raw material you purchased, you are supposed to pay the sales tax. So sales tax is been added for the cost of the raw material. Conversion cost is also to be added. And after conversion, the product is transformed from the coconut to coconut oil. Then automatically excise duty will be levied. Like that, every stage, taxes are also added. And the cost is also, after adding the taxes, the cost also increases. So this kind of additions, whenever a value added is being taken up for a product, at every stage, the taxes are also supposed to be included. Because of that, the original price of the cost has increased. Here, the consumer is affected party. But now, because of the implementation of GST, we will levy at every stage. But what we will do is we are keeping aside. We are not adding it to the cost of the product. Earlier, we used to add to the cost of the product, but now we are not adding to the cost of the product. We will come at the finally, whatever may be the cost, and we will levy GST either 18% or 12%, whatever may be. So in that 12%, which includes at every stage of taxes. So that is the reason why what we are doing, we are segregating the 12% tax into CGST, SGST also. So 6% is CGST and another 6% is SGST. So like that, for the sales tax supposed to be given for the state government, that comes under your SGST. Now excise supposed to come under the central, so CGST. So if it is between the two states, IGST is also included. So here what happens is, if CGST, SGST and IGST also is the component of tax supposed to be levied, taking that as a base, that we will be levying at the end. And the cost of the value remains the same. We are not making in between any profit. If we are making in between any profit, that profit goes to the middleman. It doesn't reach to the ultimate consumer. That's the reason why here they say anti-profiteering means we are taking the steps. See to it that your reduction in tax rate will be, so GST would lead to a reduction in tax rate, and such cost benefit should be commensurately transferred to the recipient of the supply. That means to whom you are supplying this particular commodity, ultimate consumer or a customer who is reaching. For him also see to it that it should be benefited. That is what the concept which need to be understood under anti-profiteering. This is one which we have to consider. The next we have to take into the account here is e-way bill. Now, you might have seen on roads the lorries, etc., which are transporting the goods from one place to another place. See, we never had a chance. Probably if you have a chance, you can ask those people what are the documents which they carry from one place to another place when they are transporting the goods. See, they'll have a e-way bill. E-way bill means they have a delivery challan. Probably we may call it as a delivery challan. The delivery challan they have to hold. Why? Because as and when see, any transactions which are taking place in the state, within the city, within the outskirts also, it has to be recorded. That means a permission need to be recorded with the authorities. Without the permission from the authorities, we cannot transfer the goods from one place to another place. So we are supposed to give a communication to the authorities stating that the movement of goods, when it is commencing and when it is, where to reach, where it is starting and where it has to reach. And they are supposed to have those documents to be proved, because the authorities, the customs authorities, the excise authorities, they will be there before entering to the, probably if you are going on any tour, you might be seeing somewhere the police people are obstructing the lorries and they are verifying what they are being taking, that is transporting from one place to another. That will be done. That means this, whether they have taken the communication, information, permission, whether they took that permission to transfer the movement of goods from one place to another or not. So all that will be stated in your way bill. The way bill is, e-way bill is electronic way bill. That means electronically we have to seek the permission. So before seeking the permission, he has to put forth all the details. He has to submit all the documents, and all the goods which are being transported from one place to another place, those details are also need to be stated in the electronically, and it should be approved. So once the e-way bill is being approved, they will generate e-way bill, and that bill is in the part A and part B. Two sections it has. A registered person who is transporting the goods above the value of rupees 50,000 should furnish required information in part A, the form of GST, e-way bill. That's the reason why it is called as EWB, e-way bill 01, which, from the GST common portal. He has to take that into the account. A unique e-way bill number is also being specified. The supplier or a recipient or a transporter, whoever may be, he can be able to know what is the e-way bill number. And the goods may be conveyed in respect of that supply. They return the goods or inward supply from unregistered person. So here, without the permission of the authorities, we cannot have a right to transfer the goods from one place to another. And without having the e-way bill, we cannot transfer the goods. And next, the section is part B, which is filed either by a transporter or recipient. Now, when he will file, when the goods transported can be conveyed through one own conveyance or hired one. So whatever may be the mode of transport which you are taking into the account, based on that, the part B has to be filed. Now, what are the documents are required to submit along with e-way bill? They say invoice, bill of supply, challan, transport by road, transporter ID or a vehicle number, the transporter by rail or air or a ship, like bill of entry, bill of lading, all that, letter of credit, all that, letter of understanding, all that supposed to be submitted in the form of a document so that e-way bill can be generated. Or it can be cancelled even through SMS. They will electronically also see to it that whatever they have generated can be also be cancelled. See the movement, what different types of movement, like mode of transport you are using, that also will be considered, and that information also need to be given. See, interstate movement of goods by the principal to the job worker, by principal or registered job worker, you have to take that into the consideration. So compulsorily, they have to specify the goods in the e-way bill, and it should be, the value of the consignment also should be less than 50,000. Interstate transport of handicraft goods by a dealer exempted from GST registration. See, what are the goods which are transported from one place to another state, that whether it is acceptable, whether it is required to take a permission, whether not required to take a permission, all that need to be stated. So that need to be considered. That means we have to put forth an application from the authorities. Now, validate of e-way bill. See, till 100 kilometers, 1 day e-way bill is valid. Now, in case, like let us say, if it is crossing more than 100 kilometers, then an additional day is also given. So, e-way bill has a validity also. E-way bill has a validity, whether it is 1 day or 2 days, with which you are supposed to transfer the goods. Over and above, if you take, then again it becomes a problem. So, exceptions to the generation of an e-way bill requirement also he gave you, that a goods transport there as specified in annexure to the rule 138 of CGST rules, goods transported by non-monetized conveyance, a non-motorized conveyance. So like C, etc., if you take into the account there, whether what kind of you are using, whether motor or non-motor, then the port, airport, air cargo, complex, land customs station, inland container depot, container freight station, clearance by customs, all this supposed to be considered. And in case if you are not taking any permissions, etc., penalty can be levied, and penalty for non-conformity of e-way bill, as per the rules, also to be taken into the account. The next, I think time up, the advanced rulings, etc., we will consider in the next class tomorrow. And with that, we will, customs also is there. Even we will take up that and we will try to complete by tomorrow. Do you have any doubts? Do you have any doubts?
No, ma'am.
This happens to be very interesting. Only the thing is, you need to understand and read once, twice, thrice. You will be able to understand. It is very, here what happens is, we are supposed to follow the rules. We have to follow the procedure, provisions which are being stated in the act. So whatever the act says, we have to follow strictly. Okay? Is it okay, Ma?
Okay, ma'am.
Right. I am leaving the session now. Tomorrow for same time. I think tomorrow is the last class where we are supposed to discuss about customs, as well as I think one more unit we have, right? One more unit is the GST rules, probably.
Yes, ma'am.
Yeah, GST rules and customs, and whatever is left over in this lesson also, we will discuss in tomorrow's class. Right, Ma? Thank you. I'm leaving now.
Thank you.
Hope you are following.